Good morning, ladies and gentlemen. I think it's that time that we need to start. This is an all-boards training. Today is Monday, January 19th, 2026, 9 a.m. And we have a very special person who we know quite well, Mr. Jeff Beaumont, and he's going to give us training of the boards. So, of our million documents that we have. So make sure you take proper notes, because at the end of the whole program, we're going to have a test. So you'll be all right? If you feel sleepy, there's coffee all around the place, and go get some refreshment. Pardon? Yeah. But there is a sidebar I want to touch. I was just informed that the lack of internet today is mainly because there is a problem with SCE. They have caused a problem with our internet with West Coast as well as with Ting. So let's not point any fingers or decide to do that. But with that, Jeff has been a known person to us. He is currently the attorney for the United Board, and he's been doing this training for several years. So please welcome Jeff. Jeff, you're on. Yay.
Thank you, Krish, for that introduction. I appreciate it, and good morning.
Good morning to you.
Good morning, everybody. Thanks for having me here. It's good to see everybody. I can't believe a year has already gone by. My hope is to cover the basics, but also to get into some new information that has come up since the last time we met, and then also to provide plenty of time for questions, answers, and some good dialogue. So with that, our agenda calls for the first portion to talk about the GRF Trust, and I like to do that and just go over the trust agreement, the structure of the village, and then maybe answer some questions regarding that, and then get into the board member, directors, and officers training. So to begin, and so you know, it's always nice to know your audience, right? And as Krish said, I'm legal counsel for United, been there, United's counsel for over, it's probably almost 16 years now. I represent also Seal Beach, GRF. I also represent Rossmore Walnut Creek, GRF. And so I have a perspective of how each village shares significant similarities, but also each are very unique. With respect to the underlying structure, they're all the same because they're all based on a trust agreement. And that was done by the Cortese family developing the three communities as part of their vision for active adult communities, which was a really, really iconic movement in that time. And for funding purposes, the banks required this trust agreement to be created, which is really unique because in 9 out of 10 communities, they have recorded CC&Rs. In California, just like Third Mutual has recorded covenants, conditions, and restrictions. And in this community, you have a trust agreement. And you even have master plan communities that have recorded CC&Rs, covenants, conditions, and restrictions. Then you have these sub-communities that have their own. But here you have this trust agreement. And it's interesting because even though it is still a legally binding agreement that controls how the assets are managed by GRF. It's really unique because it's an agreement that falls under a unique set of laws, the probate code. And that brings in a different element of standards, practices, legal standards. So it's a really unique aspect to Laguna Woods Village, Seal Beach, and Rossmore Walnut Creek. So with that, to understand the basic structure, GRF is still a corporation. It's a corporation that's been formed to serve a certain function, and that function is to act as a trustee. Just like I'm the trustee of my grandfather's trust, I have to manage the assets under that trust. GRF has a separate corporation, separate board of directors, separate bylaws, separate articles of incorporation. That structure is formed to come over here and manage a set of assets under a trust agreement. And that gives GRF the obligations as a trustee. And as trustee, the assets have to be managed for the benefit of the beneficiaries. And we all know who the beneficiaries are?
The mutuals.
Exactly. Not the members, but the mutuals. Each mutual, right? The Towers, Third, and United are the beneficiaries of the trust agreement. And we all also know that, and we actually looked into this years ago for you, and that was, are we sure that all of the trust assets are in the name of the trust agreement? And that was important because GRF is responsible for operating, managing, maintaining, safeguarding the trust assets. So we want to make sure all that property is in the name of the trust and the trust agreement, right? Because at the end of the day, the assets belong to the beneficiaries, the mutuals. And so that's important. I'll get into real quickly, like what the trust says and the purpose of the trust and the obligations of GRF as a trustee. But I want to back up and go over real quick the legal structure of GRF and how that came about, because we also have case law. And in Seal Beach, there was an actual court case. Has everybody heard of the Franz versus GRF case? And the late Miss Franz, who I knew very well, actually filed a lawsuit against GRF Seal Beach years ago because she requested documents from GRF. And GRF's then attorney, not me, but their then attorney said, don't give her documents. We're not subject to the Davis-Sterling Act. We're not treated like normal HOAs, and so our members aren't entitled to our documents. If I was their attorney, I would say, give her the documents. Because she's asking for just typical, routine things that people should be aware of and have. It's normal. Transparency, and it's not sensitive information. It's, meeting minutes, financials, things like that. And they took the position that, no, we're not subject to the Davis-Sterling Act. We're not an HOA. We're not obligated to provide these records. And the matter went to, she sued in small claims court, won, and then it went to, she won, and guess what GRF's then attorney did? They appealed it. They appealed it and said, we're going to challenge this decision and take it to the Superior Court. And the Superior Court ruled against GRF and created law. And it's an actual published decision that came down and said, if it walks like a duck, it talks like a duck, it's a duck, right? And said that GRF is subject to the Davis-Sterling Act and was required to provide its members certain documents. And since then, Laguna Woods Village GRF redid its articles of incorporation and bylaws and expressly stated we are subject to the Davis-Sterling Act. That's in your documents. And so that really is not related to the trust agreement, because that's more of a administration, legal structure issue. How GRF interacts with the mutuals and GRF members, because there's also, we can talk all day about this one topic. I mean, I love it. There's so many nuances and complexities to GRF and its inner workings in the community, in the village. But I'll just try to keep it quick. But again, GRF is a corporation. I'm not talking about the trustee side of it and the trust agreement. I'm just now talking about the corporate side of it. Is subject to the Davis-Sterling Act by law and under your documents, number one. Number two, you're also under the Davis-Sterling Act, you qualify as a community service organization, CSO. And you may ask yourself, well, what is the significance of that? And what do we care? Well, the significance of that and why you care is that upon transfer of a membership to GRF and ownership of a home in the village, what does GRF collect?
Trust facility fee.
Trust facility fee. And that's significant, right? To your well-being, your budget, right? That fee is illegal in California unless you fall within certain criteria as a community service organization. And you do. You do. Laguna Woods Village, Seal Beach, Rossmore Walnut Creek, all are allowed to charge this fee. All other HOAs don't for a reason, because it's illegal. You can't do it unless you qualify. And there's only a handful of organizations in California that qualify. And the legislature drew the line and said no more and grandfathered all those that could. Does that make sense? So that's why we have to protect that and make sure that we conform with the law with respect to how we collect that and safeguard, because that's a tremendous asset and resource. And that's allowed by the Davis-Sterling Act. So that's a real high-level overview of the legal structure of GRF and its application to the Davis-Sterling Act. Now, real quick, as far as the trust goes now, the trust agreement is subject, like I said, to the California Probate Code. And as GRF, having two hats, one to run its corporation and its budget and dealing with its members, the other hat is that of a trustee. And you're acting to facilitate the trust agreement. And that means what you do is you're focused on the trust assets, just like any trustee of a trust. And that doesn't mean that GRF has this unchecked authority to do whatever it wants. As a trustee, what does GRF have to do?
Act in the best interest of the mutual.
Act in the best interest of the beneficiaries, who are the mutuals, and follow the terms of the trust agreement. And that means following the purpose of the trust, which is to provide recreation services, right? To ensure maintenance of trust property. What's funny is, it's not funny, but it's interesting, the trust agreement's so outdated and antiquated. If it was up to me, it would be updated. But that's a feat in and of itself. But it mentions medical services, right? Talk about outdated. That was the intent, but that was never followed through, right? There was trade-offs and negotiation with respect to the hospital. And so medical services aren't included in the services provided by GRF, but it's referenced in the trust agreement. To protect and preserve trust property for the benefit of the beneficiaries is the primary function of GRF. And that's performed consistent with the trust agreement and the probate code. The probate code is pretty interesting because it says the trustee has a duty to administer the trust according to the trust instrument. So that's really the Bible upon which GRF operates, is that trust agreement. Solely in the best interest of the beneficiaries. And the probate code goes on to say, which is relevant for you, that if the trust has two or more beneficiaries, the trustee has to act impartially, right? Not in favor of one beneficiary over the other. All three beneficiaries, the towers, Third, United, no matter how many homes, no matter how many units are in one community over the other, GRF has an obligation to treat all of them impartially. And with respect to the standard is similar to what we're going to be talking about, is board members of our own organizations, United, Third, everybody. It's to act in the best interests of the trust because you're exercising control over other people's money and property. You're fiduciaries, Anytime you hear the word fiduciary, that means somebody's responsible for somebody else's property and assets. And that's really important to understand. That brings in the standards that we're going to talk about more later, which is to exercise reasonable care, to act in the best interests of the beneficiaries, and to follow certain standards. Financial standards are the same as the standards which we would operate in our own organizations, which is to follow the Uniform Prudent Investors Act. The Uniform Prudent Investors Act is an act that oversees how fiduciaries manage money. And that means you don't take money and throw it into the stock market and hope it, quadruples, or take all your assets and throw it into Tesla or some company, right? Your obligation is to first focus on safety, right? And then liquidity, and then yield, in that order. And that's the Uniform Prudent Investors Act. So it's very specific as to how trustees invest and manage money. What's interesting is that, and this is sometimes misunderstood over the years, but the trust has very unique characteristics. It's not owned by GRF. It's owned by the mutuals, the beneficiaries. GRF manages it. GRF manages it in its own discretion, meaning you can't dictate what GRF does and how it does it, but the assets and the trust are owned by the beneficiaries, the mutuals. There is one exception as far as the mutuals, I'll call it micromanaging, right? Because if you think about trustees, that there's a public policy. Think about it. Think about that the typical scenario where you have a very, very large family, and maybe not all family members, I don't know about yours, but my family wasn't perfect, and it's like being dealt a hand of cards, right? You make the best with the cards you have. And sometimes family are a little bit disgruntled and don't get along. And you have one person making decisions for those family members. Think about how chaotic it would be if the law said every family member can tell that one person what to do, right? Think about how chaotic it would be if each mutual could tell GRF what to do and how to do it. Chaos. That's why the probate code is very specific. The trustee acts in its sole authority and cannot be held liable unless it acts willfully, right? The exception is your bylaws were amended years ago to provide for involvement by the mutuals. And that's section 2.1.4, right? Is that raising some memories and familiarity? So back in 2014, the bylaws were amended. I think it was somewhere around there. And it resulted from a dispute, lawsuit, settlement of that lawsuit that surfaced from a proposed master recreation plan. And that plan was put together by GRF, and the mutuals said, oh, that's going too far. We're not happy with that. And it involved the use of something like, I don't remember what I did this morning, let alone that long ago, but it had something to do with GRF pulling a loan of over $10 million and using over $10 million in reserves. And the mutuals said, enough's enough. That's just too far. We don't want you going down this road, and filed a lawsuit. And it settled, and part of the settlement was we're going to amend the bylaws, and this was approved by everybody. And we want to incorporate into the GRF bylaws safeguards so GRF, if it wants to go forward with certain actions, only certain actions, it first has to come to the corporate members for corporate member input, right? And approval. Other than that, GRF does everything on its own. Is that understood? Pretty straightforward. Well, what is that input? Well, it has to do with very specific topics, such as the sale of trust property that's at least $500,000 in value. That's number one. Number two, the lease of trust property for 1 or more years. Sale or lease of property. The purchase of new property valued at $500,000 or more. And then this is a big one. The expansion of facilities or construction of new facilities. The expansion of existing or construction of new facilities, which is at least 100,000 new or additional square feet or a minimum cost of $500,000, right? And then the last one was, or is, the borrowing of money of $1 million or more. Any one of these topics trigger the corporate members coming together in this room and voting on those decisions. Other than that, GRF drives the bus as far as managing the trust assets, which I think is important. So again, it's a sale of trust property, the lease of trust property, the purchase of trust property, expansion of existing property, or obtaining loans. Those are the topics which trigger this. And then lastly, which I think is related to this discussion, is the structure upon which we're working through VMS, because I think that has similarity to the structure with respect to GRF acting as trustee on behalf of the beneficiaries, but the beneficiaries and GRF got together and created a management company, right? This VMS, Village Management Services. So as far as VMS goes, unlike Seal Beach, unlike Rossmore, Walnut Creek, Seal Beach and Rossmore, Walnut Creek are both managed by GRF. GRF wears two hats in those communities, trustee and property managers. They do both. Here, GRF wears one hat, trustee. Over the years, the village was managed by an outside management company, right? PCM. And PCM worked in this building, provided staff, and provided the services to GRF and the mutuals. Then, at one point, everybody got together and said, we want more control. We want to be more involved in the management of the village. And so they terminated PCM, and created Village Management Services. And still to this day, well, I shouldn't say still to this day, but still over these years since Village Management Services has been created. 10 years. Is it 10 years? I was going to ask you. I thought it was somewhere around there. 10 years this has been in place. I still hear comments about how we have no control. We have no control. Well, you as an individual may not have control, because God forbid if individuals had control over VMS, it'd be total chaos, right? Talk about, to me, chefs in the kitchen. But I work with, my office works with thousands of communities in the state, most of which are managed by outside professional management companies. And look, I'm not here to advocate anything. I'm just advocating the facts. So I just want to go over the structure upon which we're working through VMS. Whether you're happy, unhappy, or you have frustrations, you have far more control over your management of your community than you would if an outside company came in. Because if an outside company came in and took over, they don't want you meddling whatsoever with their staff. They don't want you meddling whatsoever with the means and methods upon which they are providing service. They're going to ask you to sign a contract. You're going to sign that contract, and that contract's going to require them to perform services. And they're going to say, we're going to provide those services to you, but how we do it is our business and not yours. Bottom line. No one's going to want you meddling with their company. Here, you have an organization owned by GRF, by Third, and by United. And each of those owners appoint representatives to serve on the VMS board. That VMS board controls VMS. And that board sets policy, just like any other board would conduct themselves, right? They're policymakers. They're not in the trenches telling painters how to paint. They're in the boardroom setting policy through policy governance. And that's your control. And so that's how we got to that structure and how VMS has been created and operating for 10 years and how that exists with GRF and those two very unique characteristics to the village here. Very unique. It's a very unique setup, like nobody else, not Seal Beach, not Rossmore Walnut Creek. Laguna Woods Village has a very, very unique, special structure. So with that, you want to maybe open it up for some questions regarding GRF and VMS, and then we can get into the board orientation portion of this and training.
Jeff, I have a question to start with.
Yes.
In the beginning, you said that we qualify to be able to collect the trust facility fee. What makes us disqualified?
Oh, great question. So under the civil code, if you started collecting a fee, and I can't recall the date, but there's a date. I think it's 2004. I'd have to look it up.
That's fine.
But there's a date. If you were collecting that fee up until that date, you can continue to collect it. But if you start collecting that fee after that date, it's illegal.
Is there nothing else that disqualifies you? Like you did something like other business or something?
There's this great question. Even if you're qualified to collect that fee, if you don't collect it properly, you could be prevented from collecting it. So one of the provisions in the civil code says you have to offer a payment plan.
Okay,
Yeah, right?
we do.
And you did that when this law went into effect.
Okay.
Because if you don't do that, then you can't collect a fee. So there's little nuances like that.
Okay, so not many other things,
No.
just small things.
No, correct.
Okay, got it.
Yep.
Okay.
Yes, sir.
Referring to GRF property, could you define property for me?
Oh, yeah, that's a good point. I heard you. So the question is, can I define GRF property? The trust assets would include the real property, the buildings, equipment, vehicles.
Okay, well then
Yeah.
let me expand that question. In order to be part of the trust. In order to be part of the trust, does it have to be titled as trust property?
Real property, yes, for sure. The real property has to be in the name of the trust. Equipment, vehicles should, yes. Equipment, it's like my trust. My trust lists my assets, right? But there's a catch-all provision that says, and any other property. It's called it's a general provision that encompasses everything else that may not be listed and held.
So I can say that any property owned by GRF, the foundation, is part of the trust.
Correct.
Okay.
And I'll give you an example, because we can't put this gavel in the name of the trust.
No, it's
Right?
It's an issue of inventorying.
Yeah.
Do I have to inventory the GRF property to know what's in the trust and what's not in the trust when I spend the transfer fee, which I understand can only go against trust property? Do I need an inventory to know that what I'm spending that on is legitimately trust property? That's my quandary. That in In our reserves today, we have facility reserves and equipment reserves. And then we have a separate account called the trust, the facilities transfer trust account. And at some point, you're going to transfer over to the other reserves to actually be spent. And so from a fiduciary standpoint, I don't want to get us in trouble by spending that transfer fees on non-trust property. But you telling me that everything that GRF owns is by definition part of the trust.
That's correct.
Okay, well, that's a big statement. That makes it much easier, I think, for the GRF board not to get into a fiduciary problem of spending money meant for the trust on non-trust assets.
Yeah.
Okay.
That's my understanding, yes. Yeah, great question.
On the
You only
On-
get one.
on the transfer fee, one of my concerns is that it's decided by the GRF board, of which I'm a member. But I've been an advocate that it can get abusive. I mean, let's make it 100,000 for every transfer. You know, at what point does that become abusive? Now, no one's called us on it yet, but you know, we just recently increased it from 7,500 to 10,000, and now I'm seeing it hasn't been approved or anything, but I'm seeing that they want to increase it. VMS is treating it as being increased 10% a year. And so I'm saying, at some point, someone's going to pull our pants down on that and saying, you know, you've gotten abusive in that fee. But I just toss it out if you have any views on that.
Yeah, no, that's a great question, because I think every community that charges a transfer fee struggles with that question every year. And what's the sweet spot? You know, what do you need to be viable? And what do you need to be attractive as a community? But then what do you need to generate to meet your expenses with the ever-rising costs? So I know Rossmore and Walnut Creek just raised theirs quite a bit. So it's definitely on everybody's radar, and it's within the discretion of the GRF board. There's no legal standard.
Yeah. I'll get out of your hair. One last question. Should the GRF board, and at least I want it, get a letter from our legal counsel telling us that all property owned by GRF is by definition in the trust?
Oh, I would talk to your GRF's attorney about that. Get them to tell you whether you need that or not. Yeah, it's a good question. And just so everybody knows, I'm just here to give general information, right? This is just general information. It's not a substitute for specific legal advice for your specific situations.
Just for everybody's peace of mind, we are here till about 12 or 12:30? 12. So if we have 25 different questions, we will not be able to go. So please try to keep your questions to one, maybe two.
This
Thank
is a
you.
quick question.
Yeah.
You said that our legal organization is unique in that we have both the trust agreement and BMS as our property manager. You said you represent thousands of HOAs. Are any of those as large as ours?
As large,
So
no,
we have
other
over
than,
12,000 homes.
I'm sorry?
We have over 12,000 homes.
I understand. I know how many homes you have.
Okay.
Yeah, I'm very familiar with that. There's a handful, but Seal Beach, Rossmore, Walnut Creek, and the village here are on their own little island, right? There are communities with as many homes, but not the complex structure you have. So yeah, there's definitely communities with a large number of homes, but you have the large number of homes with the unique structure that you're working off of, which is nowhere else to be found. Very unique.
We like to be unique.
Yes. Special. I call it special. Yeah. All right. Should we get into the now overview training part? The board member orientation training. Look, and when should we break for a rest break? What time you want to break? An hour? 10:30? 10:15?
10:15.
Okay. We'll break at 10. That'll be good. 10 o'clock. So to begin, I was getting nervous when I got here because there's probably half as many people, directors, as there are now. And I like to see as many as possible because even if you've been through this in years past, you always pick something new up, number one. Number two, even if you walk out saying, I knew all that, validation is valuable, right? And number three, what's most important to me is, from a risk standpoint, having undergone this meeting and having your board and each of your directors meet every year together and talk about legal standards, best practices, what our position as a board member, as an officer, and what our role is, allows you to be that much more effective in the boardroom. And it allows you to be that much more defensible if somebody is questioning your decisions. Hold on a minute. We take our jobs very serious. Each year we go through a professional training. Each year we understand and we're educated about the role of boards and what proper decision making is. And that gives you and gives your lawyers much more leverage to support your decisions. And it fosters better decision making. So this is a really great opportunity. It has a lot of value on so many levels. You all should feel very good, even though you may be looking out thinking, oh, you should be out walking or on the golf course, pickleball, driving down to the beach. We'll be out of this in no time. We can even end a little early if you want. But just know that what you're doing is tremendous, and you should really feel good and confident about this time right now. And we'll leave plenty of time at the end to go over any decision or questions you may have, or concerns, or stories you may want to share, as long as they're funny. That was a joke. Life's too short, right? We got to have fun doing this. So, number one, qualities of and I'm going to just burn through some of these topics. Some of them I'm going to stop and spend more time on. Take notes down, draw pictures, whatever you want to do to remind yourself of things you want to talk about at the end. But like I said, we'll have plenty of time at the end. But the first point I want to make is what are the qualities of a good director? Number one, someone that's a team player. And number two, someone that understands the structure upon which they agreed to work. And by serving on the board, you all have agreed to work on a consensus-based structure. That means you're working with a group, and even though the group may discuss certain actions and decisions that may become hotly contested, once a decision is made, regardless of what side of the fence you're on, you support that decision because that's what you agreed to, right? And that doesn't mean you have to go out on the street corner with a piece of cardboard and say, I support this decision of the board, and twirl it around if you were a dissenting director. But it means you don't undermine that decision and go out on social media. You go out, in the community and pass out flyers talking about how horrible the board is. That's, to me, the qualities of a good director, team player. And really, it goes to what is the purpose of a board member in a director's role? Yeah, I keep going back to policy governance. I love policy governance because what it does is it reminds me and it reminds all of you that we are serving in a very important capacity, like any administration that sets policy, right? You're not in the trenches, and I said this earlier, I'll keep saying it throughout this morning, but you're not in the trenches telling staff how to paint a building, right? You're not telling them which direction to mow the lawn and what kind of pattern to leave when they're done mowing the grass, right? You're setting policy, procedures. And that's the role of a board, right? Making important decisions and guiding staff on important policy decisions. The expectation of a director is pretty straightforward, which we're going to get into a little bit later in greater detail, which is an actual legal standard. I've been before many judges and juries over my 27 years representing communities. And whenever one of my clients is sued or board members, we have to go before a judge or jury and explain why their decisions met the legal standard. And the jury's going to be sitting there angry as hell because they want to be back at work. They want to be back with their family. They want to be back with their, doing their own thing and not forced to come to court every day, getting paid nothing, listening to a quabble, a fight in a homeowners association. They hate it. Judges hate HOA disputes. And even though you're not the typical HOA, any case that comes out of the village in front of a judge or jury, no one's going to like it, right? Because the feeling is they can't figure their own stuff out, and they need us to resolve their differences. They should be dealing this on their own. They're wasting our time. And I'm telling you, that's the sentiment I've felt every trial I've had. But if it gets that far, what we're going to have to show before a judge or jury is that this board acted in good faith. They acted in a manner they believe was best for their organization, and they acted with reasonable inquiry. They relied on the advice of experts, and they made decisions in compliance with their governing documents and the law, meaning they made decisions in board meetings. They weren't rogue in making decisions outside board meetings. That's the expectation of a board and a board member. And that all comes down to, like I said, compliance, following your governing documents. For United, the bylaws, the articles of incorporation, that occupancy agreements, rules and regulations. For Third, you've got your CC&Rs. For GRF, you've got the bylaws and the trust agreement. So you have all your unique governing documents, and making sure that if you're ever questioned on a decision, you're in compliance with those documents. And as fiduciaries, there's also that side where you want to make sure that you're fulfilling the various fiduciary duties you owe to your members. And this is general now because it varies a little bit from GRF to the mutuals, but same concept, which is as a fiduciary, you owe a duty of care. And the duty of care, I think, is most easily understood from a decision-making standpoint. And the duty of care is making informed decisions. Now, I'm going to pump the brakes real quick and draw a line because over the years, and some of you will kind of nod your head and know exactly what I'm talking about, some directors may feel, well, in order for me as a member of this board to make an informed decision, I have a right to go into VMS and to pull every filing cabinet open and look through every file of every employee, and then I can make an informed decision. If you don't let me do that and interrogate every VMS employee, you're preventing me from fulfilling my fiduciary duty of care. It's not how it works. It's not how it works. Because that entity, VMS, is hired to perform a service to you under contract, right? As a fiduciary, your decisions make informed decisions, and if you need information, and when I say you as a board member, that may vary, that may differ from what the information the board needs. It's a consensus-based structure. So you as a board member could come to the board meeting saying, I think we need this additional information to make an informed decision. But if the board says, no, we don't, and that's a consensus, that's what controls, right? And there's limits as to what information you can or can't get. If I come to you with a legal opinion and give you an opinion on something that you're about to make a decision on, and you say, Jeff, thanks so much for that opinion, but we want to interview your staff and figure out how you reached that opinion, I'm going to say, so sad, so sorry. You're not going to get that. You can get another lawyer, or you can just follow my advice. It's up to you. So you see where I'm going with that. The duty of care is important, but it does have limitations. It's what a reasonable person would expect in that situation. Then there's the duty of loyalty, and this is a biggie. And this is one that I see an issue with in many, many boards. And duty of loyalty has two aspects to it that we all should spend some time understanding. One is pretty straightforward. The duty of loyalty, you don't make decisions where you're in a conflict of interest, right? And that's pretty straightforward. The question is, what is a conflict of interest? I think the duty of loyalty with respect to conflict of interest is clear if the board is about to hire, and this is like the most basic elementary example, but if the board's about to hire a contractor and you're related to that person, right? Or is about to hire a company that you're part owner of. That's an actual conflict of interest. And the law, unfortunately, isn't clear as to what conflicts of interest are, other than if a decision is going to result in a direct financial impact to you, not indirect. So let's say, there's a decision to lower the assessments, and there's a realtor on the board, and someone says, well, if this passes, you're going to benefit because sales are going to go up. Well, and that's going to benefit you. Well, that may be the case, may not. It's not a direct financial impact. That's not a conflict of interest. So the law is very narrow. Conflicts of interest pertain to decisions that will result in a direct financial benefit to you. Now, that doesn't mean end of story. From a best practice standpoint, if, for example, and this has come up with United in years past, and it's worked out so well, because I think there's been a consensus about being careful how directors are involved in certain decisions. There's been times where in United, where there'll be a compliance issue with a resident, with a member. And one of the board members will be a neighbor or a friend, right? And that right there creates an appearance of impropriety if they're a friend. Or, you know what, as someone that is living close to this person, and we're about to go forward with compliance or issuing a fine or some type of disciplinary matter, I may not want my name on that because this person may retaliate against me, knowing that I'm their neighbor. So I want to recuse myself and just step aside and let the board do this without me because of my somewhat, close relationship with this person or living in close proximity. I'm very practical, and I approach, what I do to help you from a real life standpoint, thinking if I was in your position, what I would do. You're a community. You're volunteers. You're running yourselves. So life is not all unicorns and rainbows, right? And sometimes you're dealing with difficult situations involving your neighbors. So let's be smart about how we do that to make sure it doesn't come back to bite you personally and disrupt your life. You're living a time of your life where you don't need unnecessary distraction. It's not worth it. So being smart means considering the possible consequences of a decision and determining whether or not you should recuse yourself or abstain. What's the difference? Well, abstaining is, I'm not going to vote on this. Is there a motion to approve the minutes from last month's meeting? Well, I wasn't there. I'm going to abstain. That makes sense. And we have the expert parliamentarian in the room, I believe. Is she back there?
She is.
Okay.
Hi, sorry. Maybe, and Tony.
Yes, and Tony too. But there are opportunities where it's 100% appropriate to abstain. Recusing is different. Recusing, like my prior example, where your neighbor is about to get fined, right? And that neighbor may find out that you were involved in that decision and start going after you and questioning you and pinning you in the corner every time you come home from the grocery store. And so to say, hey, I don't know what's going on with that. I abstained, meaning I walked out of the room and the board dealt with that without me. That's different, right? And then recusal is different as well, right? Because that's when you actually step aside, and that to me, in the neighbor situation, that's where I would recuse myself. Abstaining is just, I'm not going to vote, right? If it's the neighbor about to be fined, I would recuse myself and walk out of the room and just take myself out of that whole discussion and decision. If there's an appearance of a conflict or impropriety, meaning a good friend is going to be involved in the decision, that's more appropriate for recusal. You're just taking yourself out of that decision. There's more nuances that I'm sure others are more qualified than me to discuss and walk you through. And the slightest facts change the outcome and recommendation. But these are concepts that each board should know exist, and make sure that you're taking advantage of them, whether it's abstention, recusal, and disclosure. When in doubt, disclose, right? If you feel that there's a decision coming up, we used to meet years ago, United and staff with me involved. We used to meet with the realtors every year, every couple of years, and talk about, what frustrations we're seeing through the escrow process and what our new policies are, so realtors could be up to speed on our new policies and how they may impact new members. That process, when it was in place, involved certain decisions regarding how we interacted with realtors. And there was times over the years, realtors were actually on the board. And during that time, those realtors would disclose, hey, I'm a realtor, I'm actively working in the village, and I'm disclosing that to make sure that there's no misunderstandings in the boardroom. When in doubt, disclose. So that's important too. Now, with respect to director conflicts of interest, just as like an aside, just know that, to no surprise in California, there's a law that says in the Davis-Sterling Act, directors can't vote on certain matters. And it lists like 5 categories of actual conflicts of interest, which frankly, we didn't need this, but it's in there. I wish it went further and was more detailed, but the Davis-Sterling Act says a board member can't disclose or can't vote on their own disciplinary matter. Jesus, are you kidding me? Are we that dumb, Thank you, legislatures. That's where our tax dollars are going. I appreciate that. Board members can't vote on their own requests for modifications to their homes. Board members can't vote on their own payment plans if they're delinquent in assessments. It's like, and it goes on. It's like someone didn't go to the University of Common Sense. So with that, there's also, I think, an important aspect of this conversation where you should be able to go to bed at night and sleep sound knowing that you're not subject to personal liability as long as you follow these standards. Board members cannot be named in a personal lawsuit as long as you're following the duty of care, the duty of confidentiality. Oh, I didn't even get into duty of confidentiality. So I talked about the duty of loyalty. Let me back up. The duty of loyalty, I talked about conflicts of interest, but then as part of the duty of loyalty, there's a duty of confidentiality. And that's really incumbent. And then let me come back to liability after this. But duty of confidentiality. I'm being facetious, but are we absolutely 100% confident that whatever is discussed in executive never gets out?
No, absolutely not.
Thank you. So it's reason for us to chuckle, and I smile when I say that, but reality, it just doesn't work. There's always someone that has to open their mouth and talk about executive session business. It happens everywhere. Don't feel special. It happens sometimes more than others, to where you have to create a special committee. And in Seal Beach, we have a special executive committee that deals with very specific sensitive matters. And that's for a reason, so we can control information, right? They have 18 board members on their GRF board. So in executive session, everything is confidential, unless it's already public information, right? Just because you're discussing something in executive doesn't mean automatically it's confidential. If you're discussing something in executive session and it has to do with something that's already known in the community, that's not confidential. It's what's decided in executive session and only discussed in executive session that makes it confidential. And each director has a fiduciary duty to keep that confidential. That's why whenever I'm emailing a board member and I look at their email address and it says Mr. and Mrs. Smith, I'm like, oh, that scares me because now I'm emailing Mrs. Smith and Mr. Smith could be reading when I'm emailing her. If that's the case, that's a breach of confidentiality, right? So you have to be very careful about emails and whatever's discussed in executive session, because if there's any reason to believe that any one of you are disclosing it, you could be in the hot seat. And worst case scenario, which is my job, there's a lawsuit and it comes out that something was disclosed by you, you're not going to be covered by the directors and officers liability insurance because that's going to be deemed a act done by you and not the board. And the directors and officers liability insurance policy only covers you for decisions or actions you make that you're authorized to make in your official capacity. And I've seen a lot of lawsuits where directors are named and they're not covered because they were doing things on their own. So that's really important that you stay in your lane and what you're doing is tied to something that you've been authorized to do, either by decision of the board, by a standing policy, by a directive from a committee, something. You want to connect the dot. So if you're in the community ever making statements or doing certain things, you want to be able to connect that to something that you can draw from as authorization to do just that. Very important.
Can I ask you a question about the emails then? So who's at fault then? So if I'm emailing something to somebody on the board, and I know it's to their open family email, should I not send it to that email?
I think with this training we're doing, we're providing everybody notice of their obligations. So now it's up to them to conform,
Okay.
not you.
Your private-
Right.
okay.
But that's not to say that as a board, you still have to manage the business of your organization and your board. So if it's known on your board that somebody has a shared email account and you've asked them about it and they said, yes, this is used by multiple people, or they may say, even though it says that, only I have access to it, only I use it, then you're doing your job. You know, you follow up and make sure that your bases are covered. That's a good decision. And we're going to get into emails a little bit further after the break. But just know that as far as the confidentiality goes, that doesn't mean just because something's discussed in executive, you can't discuss it outside as long as the board makes that decision, right? Because the board in executive session can call for a motion to now discuss this topic that we've gone over in the open, or to address it in the newspaper or in the next open board meeting, or to designate the president is authorized to do X, Y, and Z regarding this confidential matter, right? As long as there's authorization, that's what's key. But before that, it's hands-off, fully confidential. And that pertains to specifically delinquencies, member discipline, staffing issues, personnel matters, problems amongst internal problems amongst directors. All that type of sensitive information has got to be kept strictly confidential. It really does. Very important. So as long as you go through those criteria and standards, now I'm going back to that liability issue where you can sleep well at night, knowing that even though as board members, you kind of do have targets on your back as far as liability, but that's okay. Because with those targets, California law has said volunteers are immune from personal liability. As long as you act in your fiduciary capacity, making decisions that conform with your documents, that are authorized by the board, meaning you're not making them on your own, you're not rogue, you're going to be protected from personal liability. People can sue GRF. They can sue United. They can sue Third. They can sue the towers all they want. They're corporations. We live in California. You see all the billboards going down the freeway, all the personal injury attorneys? Let them. They want to sue. It's outside our control. I focus on what I have control over. I lost focus on what I don't have control. But as soon as they name you, that's where I take it personal. And that's where I work hard to get you out of that lawsuit because you're volunteers. So with that, we'll go ahead and take How long of a break do you want to take, Cash?
10 minutes.
10 minutes.
10 minutes, we'll come back, and then we'll get into the business judgment rule. Okay, so we left off talking about personal liability and sleeping well at night. I want to just impress upon you the extent of laws there to protect you as volunteers. But you have to make sure that your attorney has the tools to take advantage of those laws. So if all of a sudden we're asked, Jeff, the board's been named in a lawsuit. Here's the lawsuit, defend us. And I look at the lawsuit and I talk to you, and all of a sudden this all pertains to something that you were doing outside a board meeting. I'm limited, right? I can only do so much. So one thing that is really important is to make sure that we're making decisions in board meetings. Or if it's outside a board meeting, it's a decision that has authorization by the board, whether it's through a committee, which I'll talk about later, or specific authority given to a board member to do certain things, officers, committees, things like that. Unilateral actions outside board meetings create a lot of risk. Board members interacting with residents. Board members feeling as if they have to engage residents on rule violations. Huge area of risk. That's what staff's for. Again, you're on vacation. You should be enjoying life, right? You see something, you're serving on your board, you feel you have this higher standard and role, but just exercise constraint and discipline and say, okay, I'm seeing this, I'll just notify staff and be on my way. That's it. Don't engage. It creates significant exposure for you and for the quality of your life. Also, with respect to liability, the business judgment rule, which I've already covered, it says your job is very straightforward and your protection is plentiful as long as you act in good faith in a matter you believe is best for the organization and you make informed decisions. Now, cases actually have come down to discuss this, and I've talked about these cases in the past, and I'll just go through them real quickly right now. But the pivotal case that came down in 1999 by the California Supreme Court from a community in northern San Diego County had to do with a building that had termites, and Miss Lambden sued her board because the board refused to tent the building. And that board decided to spot treat, and she was upset and filed a lawsuit. And the lawsuit went all the way to the California Supreme Court, and the California Supreme Court said, we're not going to second guess the decision of a board with respect to how it wants to maintain and manage its community. Even if that decision isn't the best decision, we're not going to step in and second guess. As long as that decision is consistent with their governing documents, as long as that decision was made in board meetings, and as long as that decision was based on the board's exercise of good faith and with reasonable care, due care, making informed decisions. And the court went through this whole analysis about how this board met with its termite contractors, management, surveyed the homeowners, and made a decision based on what they felt was best because most of their residents were on fixed incomes. They were elderly, and tenting would put a huge burden on them, not just financially, but relocating them outside the building. And they made this decision based on information. And the court said, even though tenting is really the better way to go, we're not going to second guess. And then fast forward, and I know some of you will remember this case, to the Afan couple who have a home in Huntington Beach that they use during the summer. And in the other months, they have a home in Palm Springs. And each summer, they went out to their their Huntington Beach condo, and not once, not twice, not 3 times, 4 times, 9 times, 9 times, they got out of their car, They got their bags, they opened their door to their condo and walked through a condo full of sewage. But each time, the board responded and sent people out and cleaned it up and snaked the drain line that was kept backing up. And when the Fonz said, finally, you're not fixing the problem, you're leaving us with no choice but to sue, the Portofino Cove board said, you can't sue us. We're protected by Lambden in the California Supreme Court that said, as long as we're making a decision, we can't be held liable. And the court said, yeah, you're making a decision, but your decision isn't fixing the problem. The decision isn't doing what you're obligated to do, which is to maintain the common areas and infrastructure. Yes, but we're clearing the drain line each time it happens, but you're not fixing the underlying problem. And so the court said that the Portofino Cove board could be sued personally. So there's limits. You see the tug of war, right? And so with that, it's very important that we understand that you are protected as long as you make these decisions following this certain procedure, but there are limits as to you being exposed if you're not fulfilling your ultimate responsibilities. And, this, I don't want to get in the weeds, but I'm going to throw it out there just as an example, but coyotes in the community, right? I mean, that's something that is a tough issue because, number one, you're all responsible for managing your property, United's property, United's board. Third's board, GRF, the trust facilities and property. If there's coyotes rampant in these areas, someone can argue you're not managing these properties and keeping them safe and free of unreasonable threats and risk. Well, that's why we have to show through staff we're taking reasonable steps to address the problem. That doesn't mean eradicating the community of coyotes because that's impossible. That's impossible. That's like trying to eradicate bees from the community. You just can't do it. It's nature, right? And we came into their territory, and there's going to be a level of intrusion by wildlife. But the question is, how far do you go, and where do you stop, and where can you say you've done your due diligence and documented that you've taken reasonable steps? So if someone is hurt, either directly or indirectly because of coyote activity, we're protected, right? And that's very important. So with that, I also want to make sure that we go over the importance, which you all are so good at. You're so good at documenting your decisions. The way you take minutes, the way you track minutes, the way you maintain records through staff, it's like no other community. I mean, you're very thorough in how you do that. But that documentation is very critical. Every trial I've been in, I say this a lot, the two pieces of evidence used most against my clients are what? Can anybody guess? Emails, number one. Thank you, Tony. And minutes, number two. And so, number one, we'll get into emails, but those are a hotbed of exposure. And minutes are a great tool to use to defend yourself, but it can also be a tool and a sword to hurt you and use against you. So you got to make sure you're careful about what's in those minutes. And even though, each meeting, it may feel routine that, okay, is there a motion to approve the minutes? That's an important decision. Each meeting, that's very important to make sure that you're going through those minutes, making sure they're accurate, making sure there isn't too much information, but making sure there's, enough information to document your decisions. And it's a fine line. It's like some communities have open forum, and in their minutes, they have verbatim everything that someone's saying. Minutes are called minutes for a reason, right? They're minutes. They document action items. It's not a novel, right? So you want to make sure they're not too detail-oriented. Yes?
How about social media? To me, that's just bad as email.
It's funny, my last topic today I have risk management, and right next to it, I have social media. So yes, emails and social media, hotbed. And I'll get into social media. Thanks for bringing that up, Juanita. But for documenting decisions, minutes are really important. And with respect to, now I'm kind of changing gears and going on to the board structure. And I want to talk about real quickly officers. I want to talk about committees, and then get into compliance with respect to how we conduct board meetings, and then end with risk management and Juanita's point, which is social media and some other things. So we're kind of headed towards the finish line, and but with respect to the structure of the board, we all know that each year we elect officers, right? And this also gets into the business judgment role and protecting ourselves. Because with the officers that each year we get together and select who's the president, first vice president, secretary, treasurer, there's not just that procedure to do that, but ultimately, what are the roles of these people, right? Because we want to make sure that when these people are put into place, and Cash or Charlie or whoever's president is doing what they feel their role is on the board, there's an expectation that is shared by the board and that person, your president. And I'm just going to speak from experience over the years. I've seen, not often, but I've seen it happen a few times, to where these expectations aren't aligned, where the president feels they could do this, but the board feels they can only do this. And that's why it's really critical that the board is on the same page, that the roles of their officers are detailed through their job descriptions, right? That there's clear guidance on what the president can and can't do, the secretary, the treasurer, and the treasurer with respect to staff, turning staff's offices upside down from a financial standpoint versus working with them cooperatively and productively. So it's really critical that even though we understand behind the scenes that when these officers are elected, those are the people that drew the short straws, because now they have more work. That was a joke too. Because they do have a lot more work. Jim, am I incorrect saying that? Who here has served as president or is currently serving as president? Raise your hands high.
On any board, not necessarily.
Any board. Raise your hand high. Now, of those hands held high, is there less or more work?
More.
Right? A hell of a lot more. I see it. And I see the stress and the strain and the challenges. Man, it is a task, not for everybody. And so with that, I just want to make sure that people are healthy. They understand that those that have been selected in these positions are doing the best damn job they can, and that we're there to support them. And if there's any questions about, their roles, over communication is the best tool here to make sure we're all on the same page and we're going down the same road. Very, very critical. But that doesn't mean that these officers have more authority, right? The board has the ultimate authority. Officers just have more tasks. That's it.
Welcome.
So, yes.
You're welcome.
And relatedly, the board has the authority to create committees. And each of you have your committees, right? GRF has its committees. Who is ultimately responsible for the actions of those committees? The board. That's why it's critical that the board manage these committees. And it starts with clear committee charters, written charters, right? And then just general oversight, reporting mechanisms, making sure you're understanding what's going on, how those committees are operating, conducting meetings, how those committees are interfacing with staff. There's certain procedures that dictate how those committees interact with staff and the board. It's very, very critical that we understand that ultimately those committees are an arm of the board and doing, from the law's perspective, board work outside a board meeting. And that's the most standard, method of doing business outside a board meeting, which is by creating committees and having committees function as a arm of the board. Very effective. With respect to compliance, I think it's important that we understand just generally, you're not, I'm speaking in a couple weeks at a educational seminar on trends. And one of the trends I'll be speaking on is AI, right? Artificial intelligence, ChatGPT, Grok, all these platforms that were designed, if you look them up, first thing they'll say is they're designed for entertainment. Honestly, that's the first thing that comes up when you look these up. But people are using them as a substitute for information, accurate information, right, as a resource. And it's changing the platform upon which we work, not just with each other, but with our residents. It's really changing things. In fact, the other week, I represent a community up in Northern California by Mount Lassen and Shasta. And it's a country club, golf community, lake. They have a lot of amenities. They have a lot of people that have homes that they use for short-term rentals. And the community charges a fee. If you're going to use your home as a short-term rental, and people are going to be coming in and out of our community using our guardhouse, our gatehouse, our entry system, our staff, our roads, we're going to charge you a fee. And this is legal, by the way. And this owner that just bought not even a year ago is challenging that and asked for internal dispute resolution. And you know what IDR is, right? It's under the civil code, and it says a member can ask for IDR and meet and confer, and the code says informal setting as a means to resolve conflict informally. And this person sent this request in using ChatGPT. You can tell, you can see the headings and the way it's formatted. Anytime you use chat, you can see a mile away because the way it spits out the response, immediately. And it laid out all this law and how they want to do an IDR meeting and the agenda, time limits for each agenda item, and the legal authority for each topic that she's challenging this fee. And the board sent it to me and said, Jeff, what do we do with this? I said, it's changing the dynamics of this meeting, which the law anticipated you to sit down with this homeowner and just try to work it out informally. Now they're serving you with this legal document, which now prevents you from engaging them because you're not lawyers. Mm-hmm. And so I wouldn't spend the money, have me there. That's not what the meeting's for. But I would take that and in that meeting say, we're just volunteer board members. We rely on our attorney to come up with the rules that we have. You're challenging them on legal front. We can't respond to this because we're not lawyers. Is there anything else you want to discuss other than the law? Because if it's just the law, have your attorney contact ours. And if your attorney is Grok Esquire, then you're going to have to hire your own attorney, right? It's like, my gosh, it just changes the way we are operating and working in this environment. It's very difficult. So one thing that I want to make sure is clear, it's there for you to use responsibly, but as a board member in a board, it can't be a substitute. In the last wind of it, we had a lot of strong winds, and I've represented Leisure Village in Camarillo we've been representing for over 30 years in my firm. And it's a beautiful 55 and older community in Camarillo. Is anybody familiar with it? They have 2,200 homes and very, very expansive property. So the homes are attached, but they're single-family homes, but attached. And there's a par 3 golf course, but very wide open, spread out. And they had like 13 large mature trees come down in the last winds, and 4 of them fell on homes, and a couple of them fell on cars. So I was thinking about this program I'm speaking at in AI, artificial intelligence, and I can just envision like someone suing because a tree fell on their home and crushed them, right? Didn't happen, but I'm just assuming, worst case scenario. And a plaintiff's lawyer saying, why didn't you trim these trees? people were complaining about trees being trimmed. And again, this is me making this up. Those trees that came down, they have very, very regimented annual trimming, and they have an arborist they use, and it just happened. The soil was too damp, and yeah. But I'm just thinking about like what could happen. And what could happen is if you have trees fall down your community and it, God forbid, it hurts someone, and I envision this board like not trimming trees because they're going on ChatGPT saying, how often should you trim trees, right? And relying on something from AI to make a decision. And then God forbid someone's killed because of you relying on ChatGPT that doesn't know your circumstances, versus you hiring a professional licensed arborist that says, no, you're okay to forego trimming this year. You can do it next year. And then all of a sudden a tree falls that's just a fluke, right, that no one could have expected, and you're sued. Certified arborist, you're protected. You fulfilled your fiduciary duties. Rely on AI, and you know what's going to be nailed to the wall in that lawsuit, right? So there's boundaries there. Information purposes, great, but relying on information that comes from the web and AI and all that, not so good. I'm not sure that was a tangent I just got off on. I don't even. It's not even in my notes, but I just thought it'd be interesting to bring up. Yeah. So as far as board meetings go, you have an advantage because you don't have to worry about compliance when you hold your board meetings. Staff handles all that for you, right? It's good to know, though, generally, what the notice requirements are, especially if a special meeting need comes up and you got to get together on an unscheduled basis to call an executive session meeting, which requires 2 days notice, or a regular or a special board meeting, which requires 4 days notice. But there's communities out there where board members are trying to navigate through this themselves and post notices in the community before each meeting, making sure the agenda is attached to that notice and all those requirements are satisfied. In California, we have so many regulations, and it's important that you're in compliance because, again, from a risk management standpoint, the more non-compliance somebody can show, the more they're going to undermine and poke holes in your great decisions in governance. So it's important that we make sure that we understand how meetings are conducted, that with executive session meetings, we're disciplined to only discuss those topics that are allowed, right? Contracts, personnel matters, disciplinary matters, Gesundheit, delinquencies, there's only very specific topics that can be discussed in executive session, legal matters, and that we stand behind that. And that kind of brings us to the email topic. There was a case that came out in 2003, August 2003, called the Alta Del Mar case. And before this case, the lawyers that do what I do were pretty much on the same page, that board members and HOAs could not exchange emails, that under the Davis-Sterling Act, the exchange of emails met the definition of a board meeting. And anytime you meet the definition of a board meeting, you have to what? Take minutes, post a notice of the meeting, right? Post the agenda, all that. As soon as a meeting is formed, boom, it triggers the notice requirements, the meeting notice, the agenda. There's all these requirements that are triggered, right? That's why whenever there's a majority of the board that gets together at the same time and place, I get a little nervous. I evaluate. And if it's in a committee, we have certain language on the committee notice, right, that accounts for that. So we've made adjustments to make things work for you, but in the event of people are emailing each other, before the Alta Del Mar case came out, if you looked at the definition of meeting in the Davis-Sterling Act, that was a meeting, and you couldn't do it. Well, the Alta Del Mar case came out and said, no, board members exchanging emails is not a meeting, and it can be done. Because we don't know where they are when they send that email, what time they send it. It's at random times, different times. It's not, I'm sorry. It's not I'm talking with my hands. It's not a consensus. It's not an engagement of the board at the same time and place to discuss something that comes within the authority of the board. That was good, but it was also bad, because it was good because it brought clarity to an area of the law that really wasn't too clear, but it's bad because it sends a message to board members that lawyers aren't comfortable with. And it's because of what I said earlier, which is my experience in trials, which is the most used evidence against my clients, which are emails. And emails are a permanent record. And if you've never thought about that, please think about it today. Every time you hit send, you're creating history. You're creating a record that could be used against you, or it could help you. So you want to make sure you're very careful. As a best practice, I don't like board members engaging in discussions by email. It's a bad practice. It's a bad business practice. It is not conducive of good decision-making. It opens the opportunity for misunderstandings. It's like teaching my kids to pick up the phone and not text, right? It's like, come on, let's just talk in person, much more effective. Same with boards. Talk in person in board meetings, much more effective. If you're just exchanging information, just sharing, that's fine. You know, hey, everybody, I want you to be aware of this. You send it out. But as soon as you start doing this, dang it, I did it again. That's where you get in trouble. That's where you really start opening the door. Is it technically allowed? Under the Alta Del Mar case, as long as you're not making a decision, it's allowed. Is it recommended? Absolutely not, unless you're just sharing information. Unless you're just sharing information. But again, the more you blur that line, the more opportunity there is for conflict. Again, misunderstandings, things being taken out of context. Ultimately, a decision may be made. Or you may get to a board meeting and you may get to a decision that's made, and the members present may think, you guys already discussed this. This is just like a show. What aren't you telling us? What's being done behind the scenes? All of a sudden, there's this conspiracy theory, right? And that sometimes resonates out of the boardroom into the audience when you're making decisions. Yeah.
Jeff, I have a question. We had a very heated discussion with a number of different board members, and a certain subset wanted to get the board agenda, invite the committee members to come and have a pre-meeting so that they could educate themselves on what was going to be on the agenda, and then go into the meeting after they had done that. And some of us were arguing that that smacked of getting your votes lined up. Having a pre-meeting is not just educational, it's like stacking the deck. What do you think?
Yeah. You're their attorney. Right. We may want to take that into the boardroom to talk about it. So it's confidential. Yeah.
It was not our board.
Yeah. Yeah, but generally speaking, you know, you want to be transparent. You want things out in the open, unless it's an executive session topic. If in that context there were executive session topics, then I can see why you would want a pre-meeting to discuss sensitive matters. Let me tell you this, and again, I can't answer that without knowing the details, but I'll give you a scenario that may or may not help. The law says that you can address the formation of contracts in executive session, right? We all know that. Now, there's room for interpretation of what that means. From a philosophical standpoint, and this is just me speaking my mind and my philosophy, sharing with you what I like, which you may differ, you may disagree, and it's up to you as a board. But I like, in that context, boards discussing proposals and contracts in executive session, and talking about how great a contractor may be, or how horrible a contractor may be, or about how bad past experiences you've had with one of the bidders, right? Or how rude one of the bidders was with your residents, the last project they did, all in executive session. All that garbage should be done in executive session. That way you can discuss things in the open, honest, share information. But then when you're ready to select one of those proposals, I like to do that in open session so people see what you're doing, right? Okay, next on the agenda is the approval of the, tree trimming bids. We got 3 bids. We went through them carefully, and based on our research and staff's recommendations, we go with bid A, something like that. Technically, there's a lot of boards that do that in executive. They do everything from A to Z in executive with respect to forming contracts, even approving them. It's really up to you. I like my suggestion because it promotes transparency, but it also allows you to discuss sensitive things in executive session. You don't want to be talking about all that garbage in open session because you don't want to be sued by a contractor for defamation and destroying their business, right? So it's a balancing act, and it just comes down to your judgment. Yes, Cash.
What you're saying is slightly different from what we have been told or recommended to do, because we usually talk of contracts only enclosed, including selecting the new contractor. So, which is the correct way to do it? In the sense that, should we change our ways, or should we continue our ways? That is the big question.
Yeah, and from a compliance standpoint, you're doing just fine.
Okay.
It complies. Because in executive session, you can discuss the formation of contracts. Formation of contracts includes approving contracts. So I'm comfortable with that. My approach just suggests taking that last step in open. What you could do is you could keep your existing procedure, keep doing what you're doing, and you may already do this though, but then afterwards, that approval you make in executive session, also reference that in open session, and have a section in the open session where you're announcing, hey, we did a proposal for tree trimming, and we went through this process and selected this arborist. And put that in an open meeting and report that.
Consent calendar?
It could be in the consent calendar, exactly.
We could
Again,
do
I'm not
that.
here to disrupt, I'm just making suggestions.
I understand, but that might take, in some cases, like landscape for us, meeting is every 3 months. So if we made a decision this month, then opening it up in public would take 3 months. Instead, I think what we would do is, after our board meeting, few days later, we have a TV6 appearance and maybe announce it over there.
That's another suggestion too, yeah. For you to figure out what's best for you, for
Correct,
sure.
yeah.
But I think you've got some good options.
Correct, thank
Yeah.
you.
Yep, but you are in compliance now, so
Correct.
what you're doing is definitely in compliance.
Stay in compliance.
Yeah, yeah. With respect to emails, remember that you just cannot make decisions by email. But there is one exception. If there's an emergency, and you all have been so good over the years that I don't think I've ever seen United having the need to do this. And I don't know about any of you, but anytime there's been an emergency, we've been able to pull together a meeting within 2 days, executive session. But a true emergency, you can't wait 2 days, right? It's something that has to be done now. And those types of decisions can be done by email. And this is the trick though, as long as every board member agrees by email that it's an emergency, and then once you have that vote down, then the decision carries by majority. So it's like a 2-step approach by email. Hey, everybody, we have this emergency. This is what it is. I need you to vote on number one, if you agree it's an emergency, and if so, yes or no on this action. And that decision only carries if everybody agrees it's an emergency. And if everybody does, everybody, then you can go ahead and carry the vote by a majority. And that's allowed under the Davis-Sterling Act. That's the only time you can conduct a vote by email. All right.
I think we did that during COVID. When COVID came up, we made a decision to meet in an emergency and set up an emergency situation. And I don't know if anybody was still on the board at that time, but I was, so we did that.
Yeah, and that makes sense because you probably had to make decisions like that as to the facilities and hours, opening,
yeah.
closing. Yeah,
Yeah.
yeah, that makes sense. Yes, sir. And while you're walking up, I'm going to end by going over risk management. And risk management is a topic that I think everybody, every board should consider every year. So with that, yes, sir, you're on the floor.
The question I had was when you said emergency situation, I think you said it had to be all the board members had to agree. Is that right? So it's got to be everybody. It couldn't be just a majority.
That is correct.
Okay.
Yep. And the majority and the emergency is something that has to be acted on that can't wait the 2 days for an executive, if it's an executive session topic, or something that can't wait the 4 days if it's an open session topic, right? That has to be acted on now. And if it is, every board member has to agree, yes, this can't wait 2 days or 4 days. And if so, then every board member has to be documenting on document saying, yes, I agree. And then from there, the majority vote controls that decision.
Must you get a hold of every single board member, because some of us travel, we're on a cruise, we're in a different part of the world, and we're sleeping while you guys are making this decision. It's how long do you wait to hear from everybody, or must you hear from everybody before making that decision?
Does everybody hear that? So I'll tell you the legal answer, then the practical answer.
Yeah, really.
The legal answer is the vote doesn't happen unless everybody agrees it's an emergency. Everybody on the board. Practically, if you have and this is like the most basic example I can come up with, but if you have a pool that has a fence around it, and the lock is broke, and the gate is just flailing open, right? And there's kids all around, and the decision is we have to hire this contractor to fix the gate. Hey, everybody, this is an emergency. We can't wait 2 days. There could be kids drowning in the pool. Do you agree this is an emergency? And if so, do you agree to hire this contractor to fix the gate? As your attorney, I'm going to tell you, I don't want you waiting for everybody to send an email saying, yes, it's an emergency. Get the damn gate fixed and then ratify that in the next meeting. I'd much rather be on the side of a lawsuit where someone's going to challenge our procedure than trying to defend a death that you could have prevented by exercising common sense.
Agreed.
So there's balance, right? Again, I'm a little bit more practical.
Of course.
So with that, we'll go ahead and tie this up with the risk management discussion. And I apologize, we're going to finish a little early. So if any of you want to keep working till 12, you can come up with something.
Ask questions. We'll work on that.
Yeah. So risk management. Each year, try to have some kind of discussion about risk management on some level, whether through your committees, the board, but there's so many different areas of risk management you can explore and just make sure that we're all on the same page. Whether it's board members and their roles outside board meetings, whether it's officers and their roles and what they're doing and how they're doing it, whether it's reevaluating our committees and committee charters and making sure we're comfortable with what they're doing. Whether it's meeting, what department would you meet with? And this is my ignorance with respect to staff and how staff is organized, but what department deals with like the grounds, physical property? Landscape? So meeting with them once a year and asking them where are we with respect to trip and fall hazards, slip and fall hazards, roots uplifting sidewalks. Part of risk management is not just operations and compliance, but it's physical. Dang it, I gotta stop doing that. But it's physical property also, right? And staff has a big part of that. And we've talked about this over the years, about the work they do, not just responding to things, reactive work, not just ongoing maintenance, but proactive work also. Anticipating possible issues and preventing those issues from occurring, being proactive. And so I think a proactive approach to risk management is really key, not just to physical property, but with operations, like I talked about earlier, as to committees and officers and how we operate as a board. I can only speak to United, right? And so over the years, there's been times where as a board, we've hit reset because after a certain period of time, we are looking in the mirror thinking, why are we speaking over each other every meeting? Why are we interrupting? Why are we raising our voices? You have to sometimes hit reset if meetings aren't being, and I'm not saying that's not now. I'm talking about in the past, right? We all have a past. And there's been certain chapters in United's past where we had to hit reset and say we have to start looking in the mirror and agreeing to operate in a much more efficient, professional manner. And those are things that I think conversations that all of us should have from time to time to make sure we keep in check and we stay efficient and effective. Also, we have to look at our policies and procedures. I think it's a good idea to reevaluate our code of conducts, make sure we're all aware of them, that we're all familiar with them. Our harassment and training with respect to harassment and staff, even though VMS is this separate organization, because it's an organization owned by us, we have to make sure that we're engaging staff on a level that's consistent with our own internal policies and procedures and how we interface with department heads, right? We have procedure for that lays out how we interact with staff through committee chairs, through officers, right? We don't have this approach where it's a free-for-all as to any staff member. We have to follow certain procedures, and that's for a reason, because we want to make sure staff is comfortable in their place, that they don't feel like they're subjected to a hostile work environment. And I know many of you have come from the corporate world. I know many of you have such unique and valuable experiences to draw from, and that's what makes this place so special, is you bring those into the boardroom and share that in your decision-making process. But today, in today's work environment and climate, is much different than yesterday's, let alone 10, 20, 30 years ago. Much different. Every year it changes. And in California, it's more regulated than any other state. It really is. It's very difficult to be an employer in California. And with that, we have to be very careful about how we interact with staff, how we respond to complaints from staff, and make sure that we're engaging in work with staff in a way to where if there is a complaint, it can be handled efficiently, productively, and in a manner that's not disruptive. Because if something is brought to our attention regarding a complaint from staff, and it has to do with alleged harassment or discrimination, sexual harassment, whatever, unfortunately you have to go through this very consuming, expensive process to investigate and make sure that investigation's completed. And again, it's just not a good process, and it's not good for the company culture. So we have to make sure we're careful about that as a whole. And with that, I want to also end on, as far as risk management goes, social media. Social media is something that comes up from time to time. It's something that is not very clear as far as what we can and can't do as individuals. There's a level of understanding that as a board member, we're agreeing to abide by certain standards, which Jeff just outlined so eloquently today, right? But then just because you serve on the board doesn't mean you give up your rights as an individual, right? But where's that line? Because even though you're serving on the board, and even though you're agreeing, you're going to act as a whole, as one voice, the one voice rule prevails, doesn't mean you give up your right to go on Facebook and post pictures to share with your family that's back east while you're playing pickleball in beautiful Southern California weather, right? But where's that line drawn? Does that mean you can go on Nextdoor and respond to people about GRF business? I don't think so. I think if it has to do with your role on the board and chitter chatter in these platforms, you stay out of it. Stay out of it. That's the best practice. And I'll tell you why. Number one, you weren't given authorization to speak on behalf of the board on a social media platform. That's number one. Even if you're telling them, hey, that's a good question. You should consult with so-and-so in the admin building. Or I recommend you do this. That's still putting your nose on that platform. And what that does is now it establishes a presence on that platform. It gives that plaintiff's lawyer whose head is on that billboard on the 5 freeway ammunition that, look, GRF has a presence on this platform. They should have known about all these comments that were being made on this platform, and they didn't do anything about it. They didn't investigate. I don't want to know what's going on in that platform. Now, if you're just dying to be involved and know what's going on and being talked about, because that's just who you are, fine, read it, but don't inject yourself. Don't establish an actual presence, because it gives plaintiffs' lawyers ammunition to use to undermine the board and the board's decisions. And it creates exposure to you being attacked personally, which I don't like at all. And lastly, like I said, unless the board has a policy, social media policy, that authorizes the board members, each board member, to do things outside board meetings on social media, you're not acting with authority. You're acting unilaterally, and that concerns me, because then that runs the risk of you being involved in a dispute and not being covered by insurance. So it's just an area that's really ripe for not just conflict, but liability exposure, personal. It's just not a good place to be as a board member. As an individual, feel free to do whatever you're doing, right? But not as a board member. Okay, questions, answers. We want to come up to the mic?
Recently, we had a working group of a couple representatives from each of the mutuals and VMS. And at the end of the day, I wanted to delete one sentence from an agreement, and I did it via email. Was that inappropriate?
By making a suggestion by email?
I asked people to respond yay or nay.
And that was in a working group or a committee?
It was just an ad hoc working group of a couple of United board members, a couple of Third, and a couple of VMS. It was to work through the VMS management agreement.
If it wasn't, if it was just select members of each board and not a majority of the board, then I don't see a problem with that.
Okay, and then the other thing is you said earlier that the board members couldn't go to VMS and say, I want to see all your records. But I'm a VMS board member, and when we do things like determine the salary for the CEO, are we able to look at the salary schedule or any kind of salary information of the CEO or any of her direct reports?
Oh, that's a very good question. It's a specific question regarding VMS. I'm not VMS's attorney. I would direct that to VMS
Ms.
board
Attorney.
and their attorney.
Okay, thanks.
Yeah, it's a good question.
the topic that would like to spend some more time on is fiduciary responsibility. And since if something goes wrong, if we're sued, it's Laguna Woods Village that's sued. I won't worry whether it's GRF being sued or VMS being sued or, so my question probably is, my first question, does the VMS board have a fiduciary responsibility? I'm specifically thinking of your landscape trip case. The VMS board has the oversight of VMS. Do they have a fiduciary? I think by definition, a board has fiduciary responsibilities. But
Yes, yes. The VMS board would have a fiduciary duty to act in the best interests of VMS. And VMS has a contractual obligation to perform the services to GRF and United and Third that's required in the management agreement.
follow that up, then, does the GRF board have a fiduciary responsibility to do a risk analysis of the VMS performance, for example, in the landscape trip case?
Yes, that's a part of GRF's role, is to evaluate the services that are being provided to it by any organization. Even,
So,
Along those lines, though, wouldn't GRF only be responsible for overseeing the areas that GRF has responsibility for?
100%, correct.
So it's
Well-
not just a broad.
Correct.
GRF can go and say, well, let me see the things for United, or let me see the things for Third.
yeah.
They have to stay in their own lane.
Correct.
No, that's
100%.
well put, and
Yes.
but I'm looking for a distinction between VMS and its board and GRF and its board. So expanding on that is the fiduciary responsibility or the responsibility to meet the agreement, the trust agreement. We have in our contract that VMS should perform consistent with the trust agreement requirements. And so now we have another level of fiduciary responsibility of the GRF board to oversee VMS's consistency or performance within that. And this goes to an earlier I will take, for example, we're about to start our budget process again. And I'm not sure how it's worked in the past with, I'm new as treasurer of GRF, but I'm not sure how it worked in the past where VMS comes up with a budget and the the finance committee reviews the budget. If that's what it is, then I don't think GRF is meeting its fiduciary responsibilities just to accept the budget without going into detail as to how VMS generated that budget, what the core data was that led them to feel they needed, $1 million for security. How did they build up that number? I think that's part of the fiduciary responsibility of the GRF board. I'd like to get your feedback.
I don't know. I'm trying to figure out where to start with that one. All I can say is the budgetary process is overseen by the GRF board. And the GRF board is ultimately responsible for that budget, right? Not VMS. But the GRF board relies on VMS to provide certain data for that budget. And it's up to the board to determine whether that's appropriate or not, and to ask questions.
Okay, it's the extent. The GRF board decides on the extent of the data, the underlying data it
Correct.
needs to accept that budget line item.
Correct.
Yeah. I guess in a global sense is concern, recognition that we cannot depend on VMS. I don't think an adequate defense
Let me
is-
do this, because we have other people have questions, and I can only answer questions, not respond to concerns.
Okay, but may I ask, wouldn't that be the responsibility of any of the mutual boards when they're presented their budgets? For example, there's maintenance and construction and landscaping that go directly, charges that go directly onto their budgets that don't come to GRF. So the same thing that would apply, Jim, is that all the mutuals that are receiving budgets from VMS are responsible for confirming or asking for the underlying information of how they got those numbers. I know I would, right? And I know we have, right? So it's not just GRF's responsibility to check your budgets for, it's all of our responsibility to check our budgets with regards to those items that are direct charge to us.
Yeah, I agree. And I think from experience in the past, that's been done, that each mutual and GRF has a right and obligation and fiduciary duty to meet with VMS to go over draft budgets, numbers. But then there's also a limit, because I've seen directors make unreasonable demands on VMS for methodology and certain information that just isn't relevant and appropriate. So I think with going rogue, my confidence is that the group will, through open discussion, be able to come up with questions and data that you really need to make an informed decision. I don't know. Does that make sense? I went to law school for a reason, because I don't do budgets and all that, so. Go,
Yeah,
Ron,
Can
and
I
then-
just,
and
Jim, you have not been through the budget process, so you don't understand it, I feel. VMS, early on, I mean, this is going to be March probably, has meetings that says, this is what we do, this is how much it costs, this is what we're proposing for next year, this is what it will cost. And there's time for questions and all of that. They don't just give anybody a budget and say, this is what you need to do.
But do they provide the raw data and?
They answer any questions and have the
Do
background.
they
And
provide the data? Not that I have to track the
They will if
data.
you
out.
ask.
Do they provide the data?
They will if you ask.
they will if you ask. If you've got a question on it, they will if you ask. So,
all right.
Murad.
Yeah, just quick question. As a United Treasurer, I sometimes get questions from residents about HOA assessments or about financial matters. The last email I got a few days ago was someone asking about the breakdown of the landscaping fee of $86. So I sent somewhat lengthy email just describing the breakdown, what it covers, to make that resident comfortable about the adequacy of the $86. Is that something I should be engaging in email, or should I just ask the resident to show up at the landscaping committee, the finance committee, or the board, and ask that question then?
From a legal standpoint, because you just relayed information,
Right.
I'm comfortable with that from a legal standpoint. From a practical standpoint, from one friend to another, I would stay as far away from that as possible. Only because what I've seen in real life, where even answering the simplest questions can all of a sudden create this whirlwind and just bring you into this controversy, right? And now this person's going after you and after you and after you. That, again, I'm a worst case scenario person, and I don't want to see you in that position. This may be the sweetest person in the world, but unfortunately, it's those bad situations that kind of set you up for how you conduct yourself. Why I think, I'm fine with it. If you're comfortable, that's fine. But the better approach to me would be to refer them to somebody at VMS to answer that question, or you provide VMS with your draft, say, hey, you can use this if you want, but this is what they're asking, get back to them, or to go to a committee meeting or whatever you suggested, which sounded perfect, and have them attend or get the information from there, not the direct one-on-one.
Right. Actually, I appreciate this, because in this particular case, the reason I'm raising this is because he responded to my email saying that he's doing his own gardening. Could he please get a refund? And I did not respond to that, so you know.
Great question. Any other questions? Tony?
Yes, could you, my voice not loud enough? What'd you say, Tony? Could you expound a little bit on the difference between people in Third will have a deed, and the people in United like me to have a share of stock. Thank you.
That's a great question. Great question. So the question was, can you expand on the legal structure of Third with respect to their members owning a deed to a condominium versus in United, its members owning a stock certificate? And I love that question. I love that question because in California, there's 4 different types of HOAs, common interest developments. There's a planned development, which is the cookie cutter, single-family homes community that you see all over. There's the condominium complexes. There's the stock co-ops. And then the 4th one you see rarely, but it's a community apartment complex. So let's take the condominium complex and the stock cooperative, which Third is the condo, United is the stock co-op. And United is the largest stock co-op in California as far as number of units. Back east, they're all over the place, right? Stock co-ops are very unusual in California, but they differ significantly as far as the structure, but legally, they're pretty similar. But they're both recognized under the Davis-Sterling Act as HOAs and subject to the same regulations. The difference is in Third, the owners and members own a unit, UNIT. A unit is a condominium, and it's defined as the interior surfaces of the perimeter walls, floors, ceilings, windows and doors, surfaces. And typically, those hooks around the room here that once held artwork, those nails are inside Third's common area. The condo, if this was my condo, I would own the paint, the nice flooring, this nice dais up here, the podium, the tables, the TVs. But as soon as you penetrate the walls, you're in common area. And that common area is owned by all the owners in an undivided interest, managed by Third. And that's a condominium complex. And the owner has a deed to that unit. And even though it's just the surfaces and the airspace, it's still a deed to property. That's under California law, it's recognized property. It's a condo. And it's defined in the condominium plan attached to the CC&Rs, which defines all the units in common area. In United, all the members own in United is a piece of paper. It's a share of Microsoft. That's all they own. It's a share of United. But with that share comes rights. And part of the rights to that share is, pursuant to a signed occupancy agreement, is the right to exclusively occupy this unit right here. And because, let's say this is my unit in United, I have this stock certificate. I also have a signed occupancy agreement. In California, the law says if you have these 2 documents, it's the equivalent of real property ownership. And I have the right to transfer it. I have the right to occupy it. In California, I have the right to rent it. That was changes in the laws over the years. The difference is, as a stock co-op, you have a little bit more leverage as a corporation to screen who comes into your community and to qualify them for financial purposes, right? And to impose more conditions on who you approve as occupants. In condominium complexes, single-family homes, you can't do that. You can't ask them to show proof that you make X dollars necessarily. So co-ops are a little bit more different, as far as how the corporation interacts with the owner, because it's more of like a landlord-tenant relationship where landlords can screen tenants, but then the tenants, once they're in, they're real property owners that own the right to exclusively use that space. So it's kind of a hybrid between the landlord-tenant and condominium complex type structure. Does that make sense? Hopefully I didn't muddy the waters. Okay. Juanita?
I think there's just a little bit more involved with United particularly because of the occupancy agreement, which I think is the least understood document in any of the documents that we have here in the village. When we are leasing for 3-year periods from the mutual. We cannot get rid of it, sell our stock certificate, whatever, without notifying the United Mutual first, 10 days before it goes on the market. We've never had that agreement with the real estate agents, and they don't understand that. United owns all of it. And so that's why manor alterations is so important. We have to have approvals from United before they do anything, even paint. So people need to read that occupancy agreement, which is very different than some of the other things that they have in stock co-ops.
Yeah, and I think to dovetail on that point, Third, as a condominium complex, has recorded covenants, conditions, and restrictions, CC&Rs, which says what Third is obligated to do: purchase insurance, maintain the common areas, the grounds. But it also says what the owners are obligated to do with respect to their condos, what they can do, what they cannot do. With United, we have an occupancy agreement, which is almost like a lease agreement. I have another high-rise client in the Wilshire corridor that is a stock co-op, and they don't have an occupancy agreement. They have a proprietary lease. Same thing, but it lays out what you as a member of United can and can't do in that unit, when you can transfer it, when you have to ask permission to do things. So it is a very different structure, but it is also a structure that's recognized in California as a form of property ownership.
Both Third and United have financial requirements in order to purchase. We have income and asset requirements in Third and, of course, in United.
Okay. And that's thanks, and that's why I'm making sure I'm clear that I'm just giving general information. So Third has that's provided for in their documents, which is good because they've always had that. So that's a great reminder. And I'm glad you brought that up, because if you've never had that as a condominium complex, and then all of a sudden the board says, hey, we want to start requiring people that buy here to meet certain financial obligations, that you can't do that. But if it's always been a requirement, then you can do that. So that's probably why you have that as Third. All right, any other questions?
Seems like it's all satisfied.
All right, thank you so much for having me. Appreciate it. Yep.
Thank you very much, Jeff, for coming and educating us and bringing us up to date.
Thank you, Cash.
Thank you.
Appreciate that.
Kush.
Kush, I'm sorry.
And Jeff, if I may, I'd like to take just a minute to thank staff for the great service they've done for us this morning, setting up all the tables and the food and the coffee.
Yes,
They
everything.
were here at dawn getting everything ready for us. Really good job.
Yes, as always.
Thank you, thank you.